our submission has reached there, my lord, whether it's in my favor or against him. Lord, please come to page 767. This is a new point, my lord, I'm beginning with. The point is, my lord, other side, the learned councils, my lord, relied upon Article 213 to substantiate their interpretation. Seven six seven, para 49. Lord, the argument was based upon Article 213. The interpretation which was canvassed by my learned friends, my lord, the learned council, was that this clearly shows that there is no discretion in the governor. Lord, as a matter of fact, Mr. Datar went to the extent of saying, and I, my lord, as a constitutional interpretation, seriously object, that legislature has a right to pass even a void bill. It will have to be assented to, and only your lordship can set it aside. So
That's their argument.
yeah. So there is no option. Governor has not, forget 3 or 4, that's not the debate. There is no option at all. Then why have the governor at all? That's the simple argument. But, my lord, one of the argument was that promulgation of the ordinance, please see, my lord, the language used. I'll read, my lord, whatever is necessary, and I'll skip what is, my lord, already either orally paraphrased or earlier argued. If at any time except when the legislative assembly of a state is in session. So if the assembly is in session, no ordinance can be issued. Simple. Or where there is a legislative council in a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinance as the circumstances appear to him to require. But I am not saying that read discretion here. It has to be his discretion. There is no doubt about it, but that's not my submission. That's not the only submission.
No, but
Provided that.
His satisfaction or the satisfaction rendered on the basis of the aid and advice of the Council of Ministers.
Therefore, I am saying it is not, my lord, my submission that it is his.
Normally, the ordinance making power is of the executive.
I am not disputing that. Therefore, I said that that's not my submission. I preempted, my lord, that it has to be as per aid and advice. But there is a discretion even after aid and advice. That is what I want to show. Provided that the governor shall not, the constitutional prohibition, without instructions from the president, promulgate any such ordinance if, kindly come directly to B. Lord, please read A first, Lord, so that it can be read in context. A bill containing same provisions would, under this constitution, have required the previous sanction of the president for introduction thereof into the legislature, like Article 30, 31, etc., etc., my lord. B is very relevant, my lords. He would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president. If it would have been a bill, he would have considered it necessary, despite aid and advice given to him by the Council of Ministers, that no, this needs reference to the president. I must refer it to the president for his assent. Now, please see, my lord, see, an act of legislature of a state containing the same provisions would, under this constitution, have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. So, like Article 254, 254(2), the repugnancy. There is a repugnancy. So here, my lord, it makes it very clear that the framers of the constitution says that in the first part, yes, you will act as per aid and advice, as my lord, the Chief Justice very rightly pointed out, but he shall not do it if these three contingencies, and one of the contingencies be, he would have deemed it necessary. When the bill comes to him, he would have deemed it necessary to reserve the bill containing the same provision for consideration of the president. In that case, he needs prior instruction from the president in case of an ordinance. Now, please come to para 51. It may be pointed out that Article 213, page 767, para 41, 51. It may be it may be pointed out that Article 213 is a power to promulgate ordinances. The ordinance is promulgated by the governor himself. Subclause B will have to be read in the context. In view of the nature of the ordinance itself and the fact that the governor is promulgating the ordinance, the question for the grant of assent, first option under Article 200, will not arise, because ordinance, there is no question of granting assent. He himself is promulgating the ordinance. Similarly, second option of withholding under Article 200 will also not arise. The assembly not being in session is the precondition for exercising the power of promulgation, and therefore option of returning would not arise. Thus, there is only one option for the governor out of the four options mentioned in Article 200, and that is referring the bill for the president's assent. Now, my lord, this provision came in for consideration before a 7-judge bench of this honorable court, my lord, which was not cited till date, my lord, because this Article 213 argument came, my lord, orally in the and in written submissions also in the reply. Therefore, I am, my lord, respectfully urging the counter. I'm not in rejoinder. This is how the central government interprets the constitution. Please come to, my lord, Krishna Kumar 768. In Krishna Kumar Singh versus State of Bihar, a 7-judge bench of this court held as under. My lord, then 231 is quoted. I am skipping that. The first of the above condition arises in a situation such as the proviso to Article 304B of the Constitution. Under Article 304B, the legislature of a state is permitted to impose reasonable restrictions in the public interest on the freedom of trade will fill by the Constitution. Situations where the assent of the president will fill by the Constitution. Situations where the assent of the president is required, then point 3 above are illustrated, my lord, 254, etc., my lord, where he will have to refer it to the president. There is a clear repugnancy, my lord. That's what the court said. Illustrated by Article 254, where a law made by the state legislature on a matter enumerated in the concurrent list of the 7th schedule is repugnant to a law made by Parliament, the state law will prevail only if and to the extent to which it has received the assent of the president. These three situations make it abundantly clear that while exercising the power to promulgate an ordinance, the governor is not liberated from the limitations to which the lawmaking power of the state legislature is subject. So, my lord, as a matter of fact, Article 213 aids my interpretation that despite there being contrary aid and advice, the governor has the room for discretion. So that's the respectful submission supported by, my lord, a 7-judge bench judgment, my lord. And I have, my lord, now given the contingencies for such reservation over and above the express clauses under the Constitution cannot be illustrated exhaustively, but may depend on the following factors. My lord, please pause here for a minute. My lord, I have cited in my initial respectful submissions and even during these submissions that there are judgments which says that irrespective of constitutional provisions, there are discretions available. Calling the minister, calling someone to form the ministry, etc., etc. Lord, in none of those cases, in all those cases, the Supreme Court was very clear that these are only illustrative and not exhaustive. Because the Supreme Court was very clear in my submission that there may be circumstances which may arise in future where, other than the illustrations which we give, the governor may have to exercise his discretion. I'll come to that. But I have given, my lord, the broad parameters within which, my lord, he will have this discretion, where the bill is capable of subverting the Constitution. Nobody can dispute this, my lord. Where the bill is undermining the constitution, where the bill erodes the principles of democracy, where the bill is of such a character that it has a national implication. My lord, therefore, my lord, I have gave an example of Punjab water dispute. My lord, 4 states involved, Punjab, Haryana, Rajasthan, Delhi. There was an international treaty with Pakistan. And one assembly said that we revoke the agreement entered into. And, my lord, now we are faced with an argument that you have no option. Even a void bill, you will have to grant assent to.
This court granted stay of that.
Yes, obviously, my lord. But, my lord, that would not take away the power of the governor. My lord, kindly, my lord, appreciate. Your lordships are right. Your lordship stayed it. But that would not have taken away the power of the governor also to withhold. That you can't do this. This affects the federal structure. 4 states are affected. The center is affected because there is an international treaty in place. My lord, then, my lord, second submission, my lord, which I have made, but I wish, my lord, some of the judgments to be, only relevant parts to be shown. My lord, I gave certain examples, my lord, that suppose the assembly passes a law that we will have a separate force. They may not term it as an army. That would protect the borders of my state, for example. Or a person belonging to a particular community will not be permitted to have any trade and business. These are extreme examples. Now, my lord, this section of my written submission deals with, then in past also, Supreme Court has dealt with extreme examples while interpreting Constitution of India. Because what your lordship decides today will be the foundation as to how the country will govern, number one. Number two, the Constitution will have to be interpreted with the harshest of the examples because it will have to withstand the test. There are many acts which are passed today which possibly would not have been contemplated, my lord, 70 years back. Now, please see, my lord, I have given the example of Lord Nani Palkhiwala giving extreme examples that somebody surrenders the sovereignty, takes away the right to vote from a particular class of persons, or confers right only to a particular class of persons. Somebody say, my lord, some government come out with a say, as a, my lord, cheap publicity gimmick, that we will not tax anyone except some industrialists. These are not, my lord, these are, my lord, possible potential examples. Supreme Court has examined extreme situations. Please come to page 771, Lord, in Keshwanand Bharti. Only I'll read the highlighted part. Lord, if this is so, Lord, please see the extreme examples which are tested. If this is so, a political party with a 2/3 majority in parliament for 4 years could so amend the constitution as to debar any other party from functioning, establish totalitarianism, enslave the people, and after having effected those purposes, make the constitution unamendable or extremely rigid. This would no doubt invite extra constitutional revolution. They have considered that if we interpret it in a particular manner, this kind of bills also can be passed. Mr. Palkhiwala gave an example that suppose Article 368 is amended, conferring power to amend on the executive, that henceforth the government will amend the constitution.
These observations
Yes.
are in response to the argument that the parliament's powers to amend the constitution are unbridled. So, rejecting that argument, these observations have been made.
I'm sorry, I'm saying the same thing. I'm unable to convey it the way, my lord, your lordships have very pithily conveyed. What I'm saying is that while answering the proposition that we have unbridled power, the court has examined and conceived extreme situations. That we have to keep these situations in mind. That if we allow
Your submission is that while interpreting these provisions, we also have to take into consideration the extreme situations that may arise in,
I have brought my point.
arise in future.
Yeah, I have brought
Therefore,
my,
we have to be cautious while
yes,
holding whatever we are proposing to hold.
yes. My lord, only, I am not, my lord, then reading rest, but my lord, one judgment, my lord, which I found it interesting, is again, my lord, seven-judge bench, State of Rajasthan versus Union of India. The lordships were shown in a different context. Here, my lord, the example which was given was that this was a case of 356, my lord, President's rule. Janta government, my lord, my lord, dismissed all Congress governments in the state. And that was under challenge, and my lord, the not all, seven, yeah, my lord, if I is right, seven state governments in the state, in different states. And the question was, what can be the judicial review of 356? So 356 is an executive power. It's not a legislative power. That's a separate thing, unlike Article 200. The court says that we will examine only if there are certain exceptional circumstances, and one of the example, your lordship may come to para 773. Another extreme example, but an interesting extreme example. Page 773, my lord, the highlighted part. My lord, take for example, if your lordship, my lord, can come to that. Court is examining the justiciability or power of judicial review or the restrictions thereof. Take for example, a case where, I'm sorry, my lord, your lordship gets, my lord, somewhere, my lord, the highlighted part, fifth, seventh line from the top, last word is take. Take for example, your lordship gets, my lord.
Yes.
Take for example, a case where the president gives the reason for taking action under Article 256 and 356 and says that he is doing so because the chief minister of the state is below 5 feet in height, and therefore, in his opinion, a situation has arisen, then we can interfere, etc., etc.
This is very reasonableness.
Point
This
is,
is very unreasonable.
point is, there can be extreme, there will have to be extreme examples on which you test the
Not
constitution.
taking this point, it's an age-old technique to test the correctness of a proposition. You examine the extreme situation. It's an age-old technique, so there's nothing new.
Correct, correct.
You take
Lord.
this point, you can go ahead.
Yes, my lord. 776, my lord, I have seen withholding as a separate option, my lord. And I'll just,
Your proposition is that while interpreting the provisions of 200 and 201,
yes,
we'll have to take into consideration the extreme situations that may arise.
arise.
And therefore, we have a cautious approach.
No,
For the governor to consider that.
no, my lord. For the governor, yes. Therefore, withholding can be an option. Therefore, withholding is an option. To be used rarely, my lord. I cannot, my lord, argue that he can use it wherever he feels. But something so shockingly unconstitutional, something so, suppose some legislative assembly passes a bill that henceforth we will not be a part of Union of India. Would he, my lord, return it? Would he grant assent? Would he refer it to the president? The only thing which can be done is to withhold the assent. Therefore, I said, my lord, I'm not repeating it, that there are only 20 instances, my lord, in last 50 years. Now, Lord, withhold is a separate, my lord, action, a separate independent option. I have already argued it, but my lord, I was just trying to assist your lordships on the question, what is the meaning of the word falls through? What is the consequence of withholding of the assent? My lord, falls through, as my lord Justice Narasimha, my lord, pointed out, that it's not a constitutional term. It's not a term used. My lord, Constitution uses the term lapsing. But lapsing is a separate phenomena. My lord, suppose a bill is moved, but the assembly is dissolved, etc., then the bill lapses. But withholding, every judgment of the Supreme Court uses the word, in case the governor withholds the bill, it falls through. From where? We were, my lord, searching. From where the Honorable Supreme Court got these words? I'm not reading it, but please see wherever amendments were moved and were not accepted. The Constituent Assembly debate says that this amendment is not accepted please come to 778. I'm not reading it. 778. 778.
8.
Yes. Therefore, my lord, from the beginning of the conceiving of the constitution, the word falls through is that it
Like
dies.
yesterday you said then they were put before the Constituent Assembly and the Constituent Assembly did not approve of them. So therefore it fell through.
The governor, my lord, withholds it. Therefore, if the
Why you
word,
equate the governor with the Constituent Assembly?
no, my lord, I'm sorry, my lord. And that's not the comparison I'm making even remotely. My lord, that's not my submission. My lord, my submission, I'm sorry, my lord, there is some limitation. I'm unable to communicate properly. My submission is where the word falls through.
The origin of false through. Comes from.
The origin of false through. The origin of false through.
Origin of falls through,
Is
falls through,
constitutionally dependent.
falls through means dies. Amendment not accepted, it dies. From this, my lord, every judgment of the Supreme Court, larger bench judgments, says in the context of withholding that if it is withheld, the bill falls through, meaning thereby it dies. That's the only limited purpose.
Unless.
My lord, that I have already, my lord, I don't wish, my
Proviso
lord,
is followed.
re-repeat it, my lord, I have already, my lord, argued that, my lord, then the chart is given. Unless, my lord, I don't think, my lord, I'll take that, my lord, further.
Unless my lordship permit me, my lords. My learned friend gave this sheet to your lordships,
Yes.
which is said withheld. So it falls through, but it was passed.
Yeah?
This very bill was passed. Governor's assent was given. According to my learned.
After sending it back to
Yes,
the.
yes, his government has given. According to him, the moment he withholds intent, it falls through, contrary to my lord's own action.
No, my lord, I
This
do
was
not know
passed,
from
note
where
the
he
date.
gets it.
Assent given on 26 to 21. It became an act 15 of 2021. Anyway, I'm sorry to interrupt.
My lord, this is a reference made by the President of India. It is not necessary that one party will only appoint the governors. The argument from the other side is that perennially we will never have our governors. Let's not, my lord, go into that. My lord, here I'm not going into this question. My lord, here what happened was, let me tell you.
The Constituent Assembly was considering the provision of governors. The expectation that the framers of the Constitution had was that it would be an existence in harmony.
Correct.
Normally, while appointing the governors, the provincial governments would be taken on board. That was the
Lords,
expectation that
my
time.
lords, the system has functioned with harmony. This has a recently started phenomena with Delhi government. Something happens 32, something happens 32. This, otherwise, my lord, there are several governments, my lord, communist government, Congress government, Congress in center, BJP government in state. Did your lordships get 32 petitions? They were being taken care of. And what my learned friend is, my lord, possibly assisted wrongly is this bill was withheld and therefore it fell through. Thereafter, in 2021, some new bill was introduced.
This very bill, don't.
It cannot be this bill, my lord, after follow. Lord, Sibbal Sahab, aap
Take it up.
don't take instructions from unreliable sources.
You can place that
I will place it.
on record. Yes.
But my lord, that again, this is only to answer.
Only to examine whether after withholding, the governor again sent it to the legislature. The legislature
No.
again passed the bill and thereafter the.
No, it cannot. Lord, therefore, my only purpose of showing this is that
May I say this, Lord? Your Lordship permits.
he's
Tamil
obsessed
Nadu-
with Tamil
Tamil
Nadu.
Nadu's
I
case.
understand, my lord.
10 bills, my lord, were sent as withheld. Again, my lord, it was reconsidered and sent. And that is how, my lord, the court said, second time when it is
We
reconsidered.
are not going on the facts. Mr. Wilson, why are you unnecessarily, we know that
I'm giving example.
for you it's a important matter, but that doesn't mean that
I'm giving
you should.
example, my lord.
Lord, what happened was,
As per the practice book, at least I have seen for a couple of years, while withholding, also invariably the governor gives a reason.
they do, yes.
And sometimes it is in writing,
No, mostly in right. Yes, your lordships are right.
for informal or formal, the reasons are communicated.
And there is an end.
And after the communication of those reasons, there is nothing which preclude the legislature
To pass a
to
fresh bill.
reintroduce, reconsider
Exactly.
a bill where certain modifications may or may not.
Correct, my lord, correct.
Studied.
I bow down, my lord. That's all I am saying. The file, my lord, which culminates into this declaration contains correspondence, reasons, calling for some explanation, some details, meetings between the chief minister and the governor. My lord, this my lord, adversarial approach had never been taken. Since 50 years, we have the example. Now, my lord, page 780. My lord, I have given the authorities on plain meaning, etc. My lord, I am not troubling your lordships.
Page
But
7,
780, my lord, 780.
80 you said.
Yes, my lord, that the interpretation has to be plain textual meaning and not, my lord, anything else, my lord. But I am not reading them, my lord. They are settled propositions. I have cited judgments, my lord, which were relevant. My lord, most of them are constitution bench judgments, and only one paragraph, my lord, your lordships can permit me to read. My lord, Jayashree Lakshman Rao Patil, my lord, that reservation matter, page 781. No, it's a basic proposition, but very well articulated. I'm not reading it because otherwise I'll have to cross my time limit. But just see the highlighted part. The first and primary rule of construction is that the intention of the legislature must be found in the words used in the legislature itself.
there can't be any dispute with regard to
Therefore,
the
my lord, I didn't read, my lord. I'm not reading that.
golden rule of interpretation.
Yes. Now come to 785. My lord, kindly treat them as read. That's all. I am citing it. 785.
That allowance, you must give it to at least all 5 of us.
No,
That we know the basic rules of interpretation.
the very fact that I did not read and said that I am not reading because your lordships are aware, I started with that, my lords. Lord, 785 is a very important, my lord, point, which was raised by my learned senior Mr. Gopal Subramaniam. Discretion, aid and advice, and the necessary implication. My lord, allow me, my lord, to my lord, spend, my lord, 10-15 minutes on this point. My lord, his argument was that the discretion is only, kindly, my lord, discretion is only provided when it is so provided either by or under the Constitution. Correct? No, that was his argument. Now, please come to para 90 at page 785. So, therefore, my lord, the argument was that wherever either by or under discretion is not conferred, discretion does not exist. Correct, my lord? That was the submission. And very well articulated, my lords. My lord, para 90. The Constitution confers certain discretionary powers expressly. Certain discretionary powers are read as implied either because of the nature of the power, the subject matter of the decisions, or the functionary exercising the power. Article 200 is an example of certain implied discretions when the fact situation under which the government is supposed to act, governor is supposed to act, so requires. Even under Article 163, there can be implied discretion not to be guided by aid and advice. This is for the reason that sometimes exercise of power under aid and advice defeats the power itself. My lord, take example of MP, my lord, Special Police Establishment Act. My lord, suppose the Chief Minister is facing allegation and there is a question of sanction. 197 section or section 17 PC Act or 19 PC Act. He would still, my lord, I am saying, my lord, as a constitutional principles, I am not taking an extreme one-side view. He would still require, my lord, the aid and advice of the Council of Ministers. But he can still say that, no, this is clearly a biased advice. I am not bound by it. The council may say that don't grant sanction. And none of these provisions, my lord, the distinction was sought to be drawn that they are statutory provisions. No, the provision for which under which sanction is required, PC Act or Bharatiya Nyaya Sanhita, may be statutory, but his power which he is exercising is under Constitution. Because he is the appointing authority under the Constitution, he decides whether to grant sanction or not. There is nowhere which is mentioned that this would be done in his discretion, but that is by very nature of the power an implied discretionary power. Look, kindly read it further. It is submitted that, for example, of under the Constitution, by the Constitution there is no dispute, under the Constitution, discretion is evident in the following. The power to summon assembly does not use the word in his discretion. However, it is recognized that in certain situations, the said power can be exercised in his discretion. He can summon the assembly, my lord, to ask for the floor test, etc. Second, the power to order a floor test does not use the word in his discretion. However, it recognizes that in certain situations, the said power can be exercised in his discretion. The power under the second proviso to Article 200 does not use the word in his discretion. However, it is recognized that in certain situations, the said power can be exercised in his discretion. Lord, the power to grant sanction against the chief minister or ministers does not, I have not already pointed out. Then 356, it doesn't say in his discretion, but the nature of the power is such. He would never get advice from the Council of Ministers that you report under 356. So, my lord, to say that it has to be either by the Constitution or under the Constitution, my lord, would be a wrong constitutional interpretation. My lord, for which, my lord, for example, my lord, MP Madhya Pradesh Assembly, my lord, Shivraj Singh Chauhan, my lord, when this issue, my lord, came, Lord, this honorable court has said that this has to be done as per the discretion of the governor. Whom to call, when to summon the legislative assembly, floor test, etc., etc. They are neither by or under the Constitution. The discretion is not by or under the Constitution. It is read as an implied power because of the very nature of the power. Then, my lord, kindly come to 95. And my lord, this again, my lord, I have my lord, raised a very serious concern. I'll not say objection. How you selectively place the judgments before the court. This was done before the division bench in Tamil Nadu case and unfortunately repeated before your lordships. Despite my pointing out that two paras are not read before the division bench and therefore the division two-judge bench.
That's nothing new in the Supreme Court.
Pardon?
That's nothing new in the Supreme Court.
Their lordships.
Not only paras, but even the sentences are selectively read here.
Some words are not read. That's anyway, my lord, please see Nabam Rabia. Para 95. My lord, kindly allow me to read 95. It is submitted that it is startling that few states opposing the reference place considerable reliance on the judgment in Nabam and read numerous paragraphs of the said judgment and specifically place reliance on paragraph 147, 148, 149, 153, 154 and 155 in order to advance the argument that the governor does not have discretion while dealing with matters concerning Article 200. The said portions of the judgment were also relied upon in order to interpret Article 163, subclause 2. The reliance of the other side on the above stated paragraphs in the judgment in Nabam Rabia and the conclusions drawn therefrom is A, wholly incomplete, and B, a clear attempt to mislead this honorable court. While the above stated paragraphs of the judgment state that there is a limited area in which the governor can exercise discretion, the said judgment itself, while making the said observations from para 147 to 155, specifically at para 151 and 152 notes that as far as Article 200 is concerned, specific reference of 200, the governor can exercise the said power in his discretion. There was a similar incomplete reading before the two-judge bench in Tamil Nadu case by the petitioner at paragraph 301 in Tamil Nadu judgment the Honorable Court was led to commit the mistake by skipping or omitting the most relevant paragraphs in the same context. The state government is supposed to be a virtuous litigant and should avoid skipping or omitting the most relevant parts. Lord, please see 155(3).
No, you say that specifically at paragraph 151
Yes,
and 152, where are those paragraphs?
Lord, next page, my lord. Next page, my lord. 151, my lord.
Yes.
The important observations your lordship gets.
Yes.
The important observations in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. A relevant extract of the same is reproduced below, and thereafter please see the bold part. But the entire thing, my lord, is dealt with, but for paucity of time, I am reading bold part. The governor's discretionary power are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of the chief minister, etc., etc. We are of the considered view that the inferences drawn in Justice M.M. Panchi Commission report extracted above are in consonance with the scheme of functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of the constitutional interpretation. My lord, if your lordship would, my lord, kindly note, I don't wish to read.
That sentence is preceded by an observation that the governor's powers are not unlimited, but restricted.
I'm sorry, my lord. My lord, I'm sorry.
So you want to refer to this, that there is a specific reference to Article 200.
200, specific reference to discretion, the constitution power to withhold. There is a specific reference, and the court says that we endorse this view. This was not read, and if your lordship were to read para 301 of Tamil Nadu, my lord, this is not placed before the court, and here also it was not placed.
Trying to take us to that judgment,
Pardon, lord?
place the relevant portions of the Nabamiti.
That's the Navamuni.
No, no, I know.
No,
No, I'm sorry, man.
Navam Rebia doesn't say
No, no,
there's a power to
we
withhold.
had raised
Navam
this
Rebia
point.
does not say that there's a power to withhold. Navam
Please,
Rebia is not dealing with 200.
Please, sir, why are you
Say
agitated?
that.
I'm
Don't say
making
Naman
a
Rebia says there's a power to
constitutional
withhold.
interpretation. You are unnecessarily.
You are saying Naman Rebia says there's a power to withhold.
No, I
Naman
Lord, I'll
Rebia
not
does
enter
not say
into
that.
this tutu meme. You are doing.
Make statements
I'm
like
making, my lord, a constitutional interpretation. My lord, it may not be suitable to their interpretation, my lord.
You made a
May not
statement
suit.
which is wrong.
1, 2, 4. Anyway, my lord, I'm not.
Anyway, Mr. Solicitor, the entire judgments are on record.
Your lordships may.
All the judgments are. And, and
Your lordships,
when I came here in 2019, it was difficult to cope up with the speed of the lawyers. From first line of the judgment, they would read to the 10th line, from 10th line to 20th line. Then we had to read the judgments, entire judgments at home. This is nothing new here. It's a,
by now we are well used
we are
to it.
very well we are
The
used
earlier
to.
method was that the poor was appearing for the appellant will take the court through judgment
This one
after
out.
judgment after judgment.
With an exception of the.
I read it.
Read this paragraph also. So you have read entirety of judgments and then
From first line, somebody would go directly to the 10th line of the judgment, from 10th line to 15th, from 15th
And
to
I think
20th.
practice-
And we are lost.
Practice in all the high courts is first the paragraph containing the facts
Yes.
will always be read. So as to understand the
Understanding
context,
what context the observations are made.
yeah.
only to understand the
But, my
context.
lord, just, my lord,
Well-
be clear on my part. When I started with this matter, my lord, I did.
We are not on
Yes,
individuals.
We are
your
not
lordships
individual.
are.
Practice,
Only
practice.
practice
Let
of-
us leave it at that. Let us leave it at that. Now, my lord, next question.
At least your next generation, we should make them clear that they should not adopt this technique of reading.
Yes,
Maybe because of time.
your lordships
constraints
are absolutely right. Absolutely right.
Go back to the old system.
And multiple variations.
But in Samsher Singh, there was another, my lord, thing. Justice Krishna Iyer's judgment was read as concurring judgment. I must say, Justice Krishna Iyer does say it's a concurring judgment. But it is partly a dissenting judgment or a minority judgment. But this happens, my lord, many a times, my lord, that broadly the judge, the learned judge says that, my lord, once I had that experience, my lord, in a very sensitive case where me and Mr. Sibal were on the same side, when the pronouncement started that the bench is broadly in agreement, and I lost 2 heartbeats. And thereafter I realized that it was 3 versus 2. So sometimes, my lord, that happens. Lord, please see Justice A. N. Ray, my lord, the majority view, according to me, my lord, and concurring but partly minority view. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, please see, my lord, it's not exhaustive list. My lord, throughout your lordships have been very careful that these are illustrative because we do not know what contingency would arise. Reading further, to illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union, so and so, your lordship,
Yeah, this we already read. it.
come to 56. My lord, the bottom, the broad, my lord, the bold part. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. Now, my lord, come to Justice Krishna Iyer's judgment. Here, my lord, I may be pardoned, my lord, if I skip some words, because I may not be able to pronounce many of them. Because of language issue, my lord, not for any other reason. Kindly see, my lord, from the beginning and then the highlighted part. We declare the law of this branch of our Constitution to be that the President and Governor, custodians of all executive and other powers under various articles, shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well-known exceptional circumstances.
Situation,
Yes,
situations.
without being dogmatic or exhaustive. Then again, my lord, Justice Krishna here also says that this is not exhaustive. These are illustrative. Please,
It
my
can never
lord,
be exhaustive. It can never be exhaustive.
cannot be. My lord, they other side, my lord, Mr. Other side, my lord.
They also did not say it is exhaustive. They only said that wherever the certain provisions of the Constitution, either directly or by implication, have provided for discretion, there only the governor can exercise the discretion. The powers under 163 does not fetter him with an unfettered discretion.
My lord,
And that also appears to be from Dr. Ambedkar's speech. But Dr. Ambedkar said that it is too premature to argue, to dilate on that point, because hereinafter we will be considering the provisions wherever a discretion is vested with the governor. And maybe we can take this article for reconsideration after that, but somehow it never fell for reconsideration.
I'm not, my lord, joining issue. Your lordships are right. But why I am emphasizing this is this. The state of Karnataka's written submission as well as oral submissions, written submission para 21 specifically says that only, my lord, I'll just read, my lord, it's a short para from the written submissions, your lordship need not open. Thus, the governor is bound by ministerial advice in the discharge of his functions. Article 163 requires the governor to act in his discretion by or under the Constitution only, bold underline, in the following circumstances. Then articles are quoted. And, my lord, it must have missed their attention, my lord, I believe. Article 164 and 174 not quoted. Summoning of the assembly, calling upon the chief minister to prove his floor, it's not quoted. Because they say that only where it is provided under the Constitution, there is a discretion. My lord, therefore, my lord, they treat these instances as exhaustive. I'll complete this. My lord, please see, my lord, Justice Krishna Iyer's minority view, my lord, though which my lord, his lordship says it's a concurring view, but this part, my lord, is not in tune with the majority. We have no doubt that the Smith's statement, so and so, regarding royal assent holds good for the president and governor in India. This is contrary to the majority view. The refusal of the royal assent on the ground that the monarchy strongly disapproved of a bill or that it was intensely controversial would nevertheless be unconstitutional. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course, a highly improbable contingency or possibility, or possibility, or possibly if it was notorious that the bill had been passed in disregard to mandatory procedural requirements. But since the government in the latter situation would be of the opinion that the deviation would not affect the validity of the measure once it had been assented to, prudence would suggest the giving of the assent. Look, this is not what the majority has said. In what I have quoted, my lord, in para 54 to 55, 56. This part is a discordant note by Justice Krishna Iyer. That's all. Now, my lords, may kindly come to Lord. Lord, I have already told you, my lord, assisted your lordships by saying that all judgments which I have quoted here say that these are illustrative and not exhaustive, which were read, sought to be read as exhaustive, my lord. So I am not, my lord, going into it. Lord, now I come to, my lord, my second last point, my lord. That is, no mandamus can be issued to the governor or the president. And Article 361. My lord, this, my lord, I may take, my lord, 10 minutes. And, my lord, there is, in my submission, my lord, a direct judgment in A.K. Roy, where, my lord, this issue is considered. The question is, my lord, there are three categories of cases your lordships are dealing with when the governor's power is concerned. The first is purely executive power, namely the power under Article 356, etc., the power to grant pardon. That is, my lord, first case where your lordships have said that we have the power of judicial review. My lord, please don't treat this as an argument of arrogance that you cannot go into it. It's an interpretation that this aspect is non-justiciable. That's as a constitutional proposition. Your lordships have said that even in cases of 356 or in Shatrughan Chauhan, your lordships have said the power to grant pardon within a particular time limit, etc. The judicial review is read, though very, 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 very restrictively. Second category is, my lord, category like Article 200 and 201, which is legislative in nature, my lord, which I have already pointed out. Now, please come to, my lord, page 793. Para 112A. The issue of justiciability of precedents and the governor's exercise of functions under Article 201 and 200 respectively must receive a nuanced interpretation and must not be conflated with usual principles of judicial review. The question of denial of assent to a bill or the action of the governor to refer the bill to the president is not akin to or comparable to the exercise of his executive powers, such as pardon or imposition of precedence rule. Apart from being qualitatively different in terms of the functions, the following factors need to be considered. The suggested exercise of judicial review in case of Article 200 and 201, unlike other instances, involves three steps. Prescription of a timeline. 2. Quashing of a decision of the governor to withhold assent or quashing of a decision to refer the bill to the president. Quashing the decision of the governor to resort to first proviso instead of choosing either of the three options in the main part. And 4. A direction to withdraw the reference made to the president or returning a bill. Lord, these are the four possible contingencies your lordship will have to resort to if your lordships were to exercise the power of judicial review and make this decision making justiciable. Lord, 113. In none of the cases involving the exercise of power by the president and the governor has this court ever imposed a one-size-fits-all time frame, dehorsed the nature of the action and its complexity. Each case turns on its own peculiar facts. Now, please, my lord, read, and this is very, very important judgment, not cited by my lord, anyone so far, on justiciability. Lord, this is A.K. Roy versus Union of India. It's a constitution bench judgment. We may now take up for consideration the question which was put in the forefront by Dr. Ghatate, namely that since the central government has failed to exercise its power within a reasonable time, we should issue a mandibus calling upon it to discharge its duty without any further delay. My lord, kindly pause here for a minute. I'll just give the brief background. My lord, Justice Suryakant, my lord, was right, my lord, that fact situation will have to be given. In case of Article 200, the legislative process commences from introduction of the bill and ends with Article 200. It's a part of legislature. This was a case where a bill became an act, but the government did not notify it because it becomes effective only when the central government,
There are many acts which will come into effect from the date on.
from the date of it is notified.
Official notification in the
Notification.
official.
And government was not, my lord, doing that, government of the day. And therefore, my lord, a writ was filed that direct the government to notify the act, meaning thereby to bring the law in force. Grant of assent also brings the law in force. This also brings the law in force. And therefore, my lord, I am reading this judgment. Our decision on this question should not be construed as putting a seal of approval on the delay caused by the central government in bringing the provisions of Section 3 of the 44th Amendment Act into force. I'm sorry, not even law. Even the constitutional amendment was not brought into force. Article 22. I am thankful to my learned. That amendment received the assent of the President on April 30, 1979, and more than 2.5 years have already gone by without the central government issuing a notification for bringing Section 3 of the Act into force. But we find ourselves unable to intervene in a matter of this nature by issuing a mandamus to the central government obligating it to bring the provisions of Section 3 into force, even to the government. In my respectful submission, the threshold in case of the Honorable President and the Honorable Governor would be high.
But then the next sentence is more important.
I'm reading. I would not skip anything. The Parliament has left to the unfettered judgment of the central government the question as regards the time for bringing the provisions of the 44th Amendment into force. It is not for the court to compel the government to do that which, according to the mandate of the Parliament, lies in its discretion to do when it considers it opportune to do. The executive is responsible to the Parliament, and if the Parliament considers that the executive has betrayed its trust by not bringing any provision of the amendment into force, it can censure the executive. It would be quite anomalous that the inaction of the executive should have the approval of the Parliament, and yet we should show our disapproval of it by issuing a mandamus. The court's power of judicial review in such cases has to be capable of being exercised both, please mark this, positively and negatively. And I'll say, my lord, why I'm requesting your lordships to mark this. If needed, it has that power positively by issuing a mandamus calling upon the government to act, and negatively by inhibiting it from acting. If you have the power, you have power of both positive as well as negative. If it were permissible to the court to compel the government by a mandamus to bring a constitutional amendment into force on the ground that the government has failed to do what it ought to have done, it would be equally permissible to the court to prevent the government from acting on some such ground as that the time was not yet ripe for issuing the notification for bringing the amendment into force. We quite see that it is difficult to appreciate that practical difficulty can possibly prevent the government from bringing into force the provisions of Section 3 of 44th Amendment after the passage of 2.5 years. But the remedy, according to us, is not the writ of mandamus. If the Parliament had laid down an objective standard or test governing the decision of the central government in the matter of enforcement of the amendment, it may have been possible to assess the situation judicially by examining the causes of the inaction of the government in order to see how far they bear upon the standard or test prescribed by the Parliament. But the Parliament has left the matter to the judgment of the central government without prescribing any objective norms. That makes it difficult for us to substitute our own judgment for that of the government. May I? Government on the question whether Section 3 of the Amendment Act should be brought into force. This is particularly so when the failure of the central government to bring that section into force so far can be no impediment in the way of Parliament in enacting a provision in the National Security Act on the lines of 3 of 44th Amendment Act into force. My Lord, now this is followed in these two judgments which I am not reading, but please see, my Lord, the position which will emerge. My Lord, and in a different context, my Lord, Justice Narasimha, my Lord, did, my Lord, indicate that. My Lord, kindly, my Lord, examine this. I'm saying it, but what it means now. My Lord, kindly appreciate, my Lords. And I'm sharing this concern because your Lordships would be deciding henceforth what will be the course of action. My Lord, the 5-judge bench says that the power includes positive as well as negative.
Negative. No, no.